Yes, Srimati, please start here.
Sure, sir. Just a second.
Okay, sure.
A very hearty good evening to everyone. Welcome to 2 weeks online national capacity building program on alternative dispute resolution organized by Sambhav Initiative and Pro Bono India. Today, we'll be conducting two very insightful sessions. The first session is going to be conducted by Ms. Navita Kalra, ma'am. In the first session, she'll be giving a general overview. The second session will be conducted by Mr. Ronak Dhillon, sir. Now, I'd like to proceed with the first session, and I'd like to give an introduction of our esteemed guest, Ms. Navita Kalra, ma'am. Ma'am has more than 4 years of experience in the academics. She is currently working as an assistant professor at School of Law, Dr. Vishwanath Karad, MIT World Peace University, Pune, and is the faculty in charge for the Alternative Dispute Resolution Cell. She has previously worked at Symbiosis Law School, Nagpur, and Kalinga University, Naya Raipur. She completed her BA LLB honours from Guru Gobind Singh Indraprasth University, Delhi, and LLM from National Law Institute University, Bhopal. She is currently enrolled as a PhD scholar at Rajiv Gandhi National University of Law, Punjab. She has also completed a PG diploma in arbitration and mediation from MNLU, Mumbai, and is a young member at International Council for Commercial Arbitration and Young Singapore International Arbitration. She has participated in various national and international conferences and has publications in reputed journals. She has also undertaken training programs on new criminal laws for Maharashtra Police as well as law students. She has also completed master's training in gender sensitization. Her interest areas include arbitration, criminology, and data protection. A very hearty good evening, ma'am.
Yes, thank you so much for that
Over to you.
introduction, Samruddhi. Okay, I'll just take a minute to share my screen. Okay, I hope that my screen is visible.
Yes, ma'am, it is.
Okay, all right. Thank you. Okay, so good evening, everyone. So my name is Nuvita Kalra, and today I'll be giving a brief overview about the Arbitration and Conciliation Act of 1996. So before I get into this act, first I'd like to give you an idea about what is ADR. So ADR, as it means alternative dispute resolution. So as all of us know, the courts in India have been, struggling with the pendency of cases, with the backlog of cases, because of which we have not been able to provide access to justice to our citizens and people who are living in India. And that has affected the idea of justice amongst the people of India. And we don't want to have a negative perception about justice in India. And for that reason, we were looking for some alternatives, right? We wanted that justice should be accessible to all. And in order to ensure that, we wanted some alternatives. And that is how we came up with alternative dispute resolution methods. So anything which does not involve courts, because the courts are already burdened, they already have a lot of backlog, right? So we came up with these alternatives, which includes mediation, conciliation, arbitration, lok adalat, judicial settlement, and you also have mini trial. All right, so these are the different types of ADR that exist in India as well as in other countries. All right, now since today we'll be talking about Arbitration and Conciliation Act, I'd like to begin with what is meant by the term arbitration. Okay, so arbitration is a kind of ADR, which means that the court is not involved in such dispute resolution. However, what makes arbitration different from other types of ADR is that in most of the ADR, like mediation or conciliation or judicial settlement, we focus on facilitating a compromise between the parties. We focus on facilitating a settlement between the parties, that they should settle the dispute by themselves. All right. But that does not happen in case of arbitration. So in case of arbitration, our focus is not on if facilitating a settlement or compromise between the parties, but our focus is on adjudicating the dispute between the parties. All right. So similar to what happens in court, that there is a party who is claiming that something wrong has been committed to him by another person, and then there is a neutral third person who gets to decide that whether the claim that is being made is true or not. All right. So when you go to the court decides that whether the one who has filed the case is the one who is speaking the truth, or one who is defending the case is the one who is speaking the truth. All right. So at the end of it, the neutral third party, which is the judge, it comes to a decision, right? That it comes to a decision that whether the plaintiff is the one who has won the case, or the defendant is the one who has won the case, right? Similarly, we do it in arbitration as well. In arbitration, we appoint a neutral third person known as the arbitrator, and we present our case to such neutral third person, and this person comes to a decision. Now, how is it different from litigation? How is it different from what happens in court? So it is actually very similar to what happens in court. However, this procedure does not happen within the court premises. Okay, it does not happen before a judge. It does not happen in a court, even though the procedure seems very similar to what happens in litigation. All right. So arbitration is also a kind of ADR because this entire procedure happens outside of the court. All right. Now, if it is very similar to what happens in court, then what are the advantages of arbitration? Why have arbitration in the first place? All right. Now, what sets arbitration apart from a court procedure is basically choice of the parties, control by the parties. All right. So if you go to a court, you do not have a control over the procedure. You are bound to follow the civil procedure. You are bound to follow the Evidence Act. You are bound to follow the orders of the judge who has been appointed. You do not have any choice with respect to that who will be appointed as a judge in your case. And even if you don't want to go for litigation, probably you may be forced to go for litigation. All right. You may be forced to undergo the procedure that is given by law. You may be forced to undergo the rules of evidence that has been given under the Indian Evidence Act. All right. So in case of litigation, in case of court procedure, the parties have no choice. The parties have no autonomy. All right. The law also decides that which courts can they approach. All right. So if, for instance, the parties want to approach a court in Delhi, however, according to CPC, the courts in Delhi do not have the jurisdiction. So they can't file a case there. All right. So according to the law, they have to file the case in the court, and they do not have a choice in that matter. All right. Now, in case of arbitration, we want to give this choice to the parties. Okay. We want that the parties should feel that the dispute resolution is in their hands. Nobody is compelling them. Nobody is forcing them to follow a procedure that they don't want to follow. Okay, so first of all, in case of arbitration, the parties get to decide what procedure will be followed in arbitration, for how long the arbitration will go on, who will be appointed as an arbitrator, by what procedure that person will be appointed as an arbitrator, where is the arbitration supposed to take place. Okay, so they can decide all of these things which they can't do in case of litigation. Another very important advantage is that arbitration ensures confidentiality or privacy. So any court proceedings that happen, they happen in an open court, which means that it is open to the general public to witness what is going on in those court proceedings. A lot of times what happens in those court proceedings are also published. All right. The judgments are published, or the proceedings are published in social media, or they are reported in certain websites or newspapers. All right. So they are not at all confidential. Parties do not do not enjoy any kind of privacy or confidentiality as far as their dispute is concerned. However, in case of arbitration, the entire proceedings happen behind closed doors. Only the arbitrators and the parties, along with their counsels, or if there are any administrative staff, or if there are any witnesses, only those people are allowed to be inside that particular room. No person of general public can just walk in and see what is going on in the arbitration proceedings. So as far as sensitive disputes are concerned, also commercial disputes where the companies, they are not very comfortable with disclosing certain information about their operations, they prefer to go for arbitration. Also, in case of litigation, the person who is the neutral third party is an expert in law. The judge is an expert in law. He may not be particularly an expert in any other subject matter. All right. However, in case of arbitration, the person that you are appointing as a neutral third party, as the arbitrator, it is not necessary that he has to be an expert in law. All right. So, for instance, if the dispute is regarding some construction work, the dispute is arising out of a construction contract. Now, thereby, the parties have the complete choice. They can appoint a person who is an expert in construction disputes to be appointed as an arbitrator. All right. So if the dispute involves very technical issues, then in that circumstance, it is beneficial to go for arbitration. All right. Flexibility, as I've already told you, the parties get to choose everything regarding the entire arbitration. Enforceability. So basically, any decision that is made by an arbitrator or an arbitral tribunal in India can be enforced in other countries as well quite easily. And the procedure is not that complicated, which also makes arbitration quite beneficial. All right. Now, coming to types of arbitration. So there are many types of arbitration, but these are the four most basic types of arbitration. So domestic and international. So domestic arbitration is basically when the parties to the dispute are residents or they are located in India and the arbitration is taking place within the territory of India, then that makes the arbitration a domestic arbitration. So if the parties are Indian or they are located in India, or the arbitration is taking place within the territory of India, that makes it a domestic arbitration. International arbitration is that when a foreign entity is involved in the arbitration, it makes it an international arbitration. So if the dispute is between a person who is a resident of India and a person who is a resident of, say, Dubai, and so the arbitration between them will be an international arbitration because there is a foreign person who is involved in that arbitration. Now, if the arbitration is taking place in India, if such an international arbitration is taking place within the territory of India, that would also make it a domestic arbitration. Okay, because as far as the territorial application is concerned, even though some foreign entity is involved, it is an international arbitration. But because it is happening within the territories of India, that still makes it a domestic arbitration. However, if such parties are conducting their arbitration outside India, then it is a foreign arbitration for us. Okay, so it is a possibility that a person who is an Indian citizen and a person who is a German citizen, they are conducting their arbitration somewhere in Germany. So it is an international arbitration, but for us, it is a foreign arbitration because it is happening beyond the territories of India. Now coming to the next two types, which is ad hoc arbitration and institutional arbitration. So ad hoc arbitration is basically when the parties, they choose the entire procedure regarding the procedure that is supposed to be followed in arbitration, and also the procedure that is supposed to be followed for the purposes of appointment of arbitrator. All right. So, and conversely, in case of institutional arbitration, the parties, they opt for the services of an institution. So there are certain organizations which offer arbitration services. All right. So they give you arbitration services. They make, the arbitration process very easy and convenient for you. they have certain rules. So if the parties have opted for institutional arbitration, they are supposed to follow the rules of that particular institution for the purposes of conducting their arbitration. So they don't have to spend their time, energy, and resources on deciding on everything. On their behalf, the institution has decided as per their rules. Okay, so you have very popular institutions like SIAC. SIAC is Singapore International Arbitration Center. Uh, you have IAMC in India, which is International Arbitration and Mediation Center. So they provide arbitration services whereby they have certain rules, and arbitration, if under their institution is selected, it has to be done according to those rules. But in case of ad hoc arbitration, the parties, they decide everything, that what procedure is going to be followed, where the arbitration is going to take place, what will be the procedure for appointment, what will be the procedure for challenging the appointment. Everything is decided by the party. So they have to spend a lot of time, energy, and resources on all of this decision making. So in case of ad hoc arbitration, the decisions of the parties are often supplemented by the arbitration law. All right, so particularly the Arbitration Conciliation Act of 1996. Now that we have got a general idea about arbitration, coming to the development of arbitration law in India. So basically, it is not that arbitration is something which is a modern concept as far as India is concerned. It has been in existence for a long period of time. And the first arbitration law was introduced in India in the year 1899. So this law was based on the English Arbitration Act of 1899. And however, the problem with this law was that it was applicable only to the presidency towns of Bombay, Calcutta, and Madras, and not to the rest of India. So when the Code of Civil Procedure was brought in the year 1908, the second schedule was added to CPC, by way of which the 1899 Act was made applicable to the entire country and not only to the presidency towns. Now, since at the international level also, we wanted to promote arbitration. We wanted to make arbitration as convenient as possible. And for that purpose, what we did was we entered into a convention. So there is a very famous Geneva Convention on enforceability of foreign arbitral awards. So basically, if an award is passed in India, the award can be enforced in any other country, all right, apart from India, by courts apart from India. All right. So to make that enforcement of award easier, for that, we entered into this Geneva Convention. And India was a signatory to this convention. And in order for us to apply the provisions of the Geneva Convention, since we were a signatory, we came up with a law. The law was Arbitration Protocol and Convention Act 1937. So basically, that on what grounds we can enforce an award which has been passed outside of India to be enforced by the courts in India. Now, because there were certain defects under the Geneva Convention, uh, another convention was brought into place known as the New York Convention. So the Convention on Recognition and Enforcement of Foreign Awards was introduced in the year 1958. Again, India was also a signatory to this convention. So again, we had to bring a law in order to apply the provisions of the New York Convention. All right. So we came up with the Law of Foreign Awards Recognition and Enforcement Act of 1961 in consonance with the New York Convention. All right. Now, because in 1936, a new English Arbitration Act was introduced, nullifying the 1899 law. And to bring our Indian law in consonance with that English law, we also brought in the Arbitration Act of 1940. All right. Now, this Arbitration Act of 1940, it dealt with only domestic arbitrations, which means only those arbitrations which were being conducted within the territory of India. So in the year 1961, we had three laws as far as arbitration is concerned. Okay, so we had the 1937 Act, we had the 1940 Act, and we had the 1961 Act. All right, so that was creating a lot of confusion. Secondly, the 1940 Arbitration Act was criticized a lot because we wanted people to opt for arbitration because it is much speedier, it is much more convenient as compared to court procedure. Court takes time, it takes years. But what we saw was under the 1940 Act, the domestic arbitrations in India, they were taking years, even 10 years, 20 years. So then what is the purpose of having arbitration if the same amount of delay is happening as what we saw in court procedure? All right. And also, um, because at in the year 1991, we were promoting liberalization. So we wanted to open up the economy. We wanted competition to take place. We wanted to promote businesses being set up in India. However, people were very reluctant to set up business in India because the dispute resolution process in India is very tedious. And that is why they were not very willing to set up business in India. So we wanted to promote arbitration as a dispute resolution, which is much more efficient, convenient, and speedier. All right. And also in the year 1980, UN Citral is United Nations Commission on International Trade Law. So UN Citral came up with rules on conciliation. So basically, they wanted to make international trade as convenient as possible. And for that purpose, they thought that any dispute arising out of international trade, conciliation can be a good option for the disputing parties. So that is why they came up with rules on conciliation in the year 1980. Now they thought that, a lot of parties, they don't want to go for settlement. They still want to go for adjudication. So arbitration is a good option. So in the year 1985, UN Citral came up with a model law on arbitration, which is basically model law on international commercial arbitration. So taking into consideration all these factors, right, that we have three laws, 1940 Act is not efficient, there are rules on conciliation, there is a model law on international commercial arbitration, where we want to promote liberalization. And that is why what we did was we repealed all these three laws and we came up with the Arbitration and Conciliation Act 1986. So what we did was we incorporated the Geneva Convention, we incorporated the New York Convention, we incorporated the model law on international commercial arbitration, and we incorporated the rules on conciliation, all of it under one law. So that there is no confusion, there is no chaos, and our arbitration law is up to standard of what is followed by all the other countries in the world. All right. So this was the basic historical background as far as arbitration, the Arbitration Conciliation Act 1996 is concerned. Now, what were the objectives behind the 1996 Act? So basically, we wanted to minimize the role of the courts. Why 1940 Act was failing is that because it allowed the courts to intervene at different intervals. And when courts were intervening, delays were being caused. So we wanted to take away those powers from the court, because of which they were causing delays to the arbitration process. Also, we wanted to have a comprehensive law regarding arbitration in India instead of having, scattered three laws as far as arbitration is concerned. And another defect that was there under the 1940 Act is that once a decision was made by the arbitrator, the decision that is made by an arbitrator is known as an award. Now, the parties had to go to the court, get the award recognized as a decree of the civil court, and then enforce that decree. Okay, so again, this procedure caused a lot of delay. So we wanted to, take away that delay. And therefore, by this act, what we did was we said that any award that is passed by an arbitrator or an arbitral tribunal is enforceable as a decree of a civil court. So you don't have to go to a court, get it recognized as a decree, and then you have to go and enforce it. Under the 1996 Act, you can directly go to the court and ask the court to enforce that award as if it is a decree passed by that court. All right. So with all of these objectives, we introduced the 1996 Act. Now, as far as the structure of the Act is concerned, we have the Act is divided into 5 parts, out of which Part 1A has been added very recently in the year 2019. So Part 1 exclusively deals with domestic arbitration. Part 1A deals with Arbitration Council of India. So basically to regulate the arbitration in India, to ensure quality of arbitral institutions in India, we have set up a regulatory body called Arbitration Council of India under Part 1A. Now, part 2 deals with enforcement of foreign awards. So what was given under the 1937 Act, we have added under Chapter 2, which is as per enforcement of foreign awards as per Geneva Convention. And what was given in New York Convention under the 1961 Act, we have added it as Chapter 1 of Part 2, which is recognition and enforcement of foreign arbitral awards, which is also known as the New York Convention. Part 3 deals with conciliation, which has now, after the Mediation Act 2023, has basically become redundant, because according to the 6th schedule of the Mediation Act 2023, now there is no difference between the terms arbitration and conciliation, mediation and conciliation, which means that they're supposed to be treated the same. If I'm talking about conciliation, it means that I'm talking about mediation. So now there is no difference that exists between mediation and conciliation. So as per the 6th schedule of the Mediation Act 2023, all the provisions dealing with conciliation under the Arbitration and Conciliation Act will no longer be applicable after the act has come into force. And part 4 deals with the supplementary provisions or the miscellaneous provisions. Now, as far as the amendments are concerned, it is only very recently that we have recognized that there are certain defects in our arbitration law, even though our objective behind the 1996 Act was quite good, but we accept the fact that there are certain defects in it. We accepted it quite late because we started amending it only in the year 2015. So the first amendment or the major amendment came in the year 2015. And the purpose of this amendment was basically to restrict the power of the courts as far as arbitration is concerned. See, as I told you, under the 1996 Act, our objective was to minimize the intervention of the courts. However, what we observed was, despite this objective, the courts were still intervening. They were still taking a lot of time as far as arbitration applications were concerned. And we did not want that to happen. So the major objective of this 2015 amendment was to restrict the powers of the court further, so that their powers are very limited as far as arbitration is concerned. The next major amendment was the 2019 amendment. Now, 2019 onwards, the amendment that have taken place, our focus has been to promote institutional arbitration in India. So why do we want to promote institutional arbitration? Because institutes have their own rules, they have their own set procedures that makes the arbitration much more convenient and speedier as compared to ad hoc arbitration. So we want to make India a hub of arbitration. And in order to do that, we have to promote institutional arbitration in India. So the objective behind 2019 as well as the 2021 amendment has been to promote institutional arbitration. Now, currently, the government has also introduced a draft of the 2024 amendment bill of the Arbitration Conciliation Act. Again, the emphasis is on promoting institutional arbitration by way of that draft as well. So this is the 6th schedule that I was talking about, by way of which now the provisions related to conciliation under the Arbitration and Conciliation Act are no longer applicable. Whatever procedure is given under mediation will also be followed for conciliation. So no separate procedure is supposed to be followed for conciliation as of now. Now, briefly talking about the process of arbitration as given under the Arbitration and Conciliation Act, what is so different about arbitration is that an arbitration cannot happen unless and until there is a mutual consent of the parties to submit their dispute to arbitration. So if there are two parties to a dispute and one of the parties, they are not comfortable with arbitration, then no arbitration can take place. So there has to be a mutual consent. There has to be a consensus ad idem as far as arbitration is concerned. If there is no consent by both the parties, then there is no arbitration. Now, the way in which the parties express their consent to submit their dispute to arbitration is known as an arbitration agreement. So basically, Section 2, subsection 1, Clause A, and Section 7 of the Arbitration and Conciliation Act, it has provided for an arbitration agreement. Now, an arbitration agreement, in order to be valid, has to be in written form. So oral arbitration agreements are not valid in India, and arbitration agreements can be entered into either before the dispute has arisen or even after the dispute has arisen. All right, but provided that it is in written form. Now, why is arbitration agreement important? As I said, it tells us that there is a mutual consent between the parties to refer their dispute to arbitration. It also helps us to ascertain a lot of elements related to arbitration, like where will be the arbitration conducted, who will be a part of the arbitral tribunal, what will be the procedure for appointment of the arbitral tribunal, what will be the language of arbitration, what procedural rules are going to be followed in arbitration, what rules of evidence will be followed in arbitration. So we can include all of these things in our arbitration agreement. Now, even though that arbitration can be in the form of a clause, so generally there is a contract. If there is a contract between the parties, there is a dispute resolution clause or there is an arbitration clause. All right. Now that clause by itself is considered as an arbitration agreement. Okay. So if there is no arbitration agreement, there cannot be an arbitration. All right. And it is important that it has to be in written form. Now, there is a possibility that there is an arbitration agreement between the parties. However, uh, because of the public policy of India, we can't allow arbitration to happen for that dispute. Okay. So there are certain disputes which cannot be referred to arbitration in India. So there are certain non-arbitrable disputes in India. For example, matrimonial disputes. So if there is a husband and wife and they are seeking a divorce, they can't go for arbitration. They have to go to a family court because only the family courts have the power in India to grant a divorce. Not even a criminal court or a civil court or an arbitration have that power. Okay, so even if there is an arbitration agreement between the husband and wife to refer the dispute to arbitration, however, arbitration cannot happen in their case because the dispute itself is non-arbitrable. Then it also includes, insolvency matters, criminal matters, because these fall under the exclusive powers of either the NCLT or the family courts or the criminal courts. Okay. Now, coming to the constitution of the arbitral tribunal. So once the arbitration agreement has been entered into, the parties can also decide that how their arbitral tribunal is going to be composed. Now it is completely up to the parties that how many members, how many arbitrators they want in their arbitral tribunal. They want one, they can have one. If they want more than one, they can have more than one. However, the only requirement under Section 10 of the Arbitration and Conciliation Act is that it has to be odd in number. So even arbitrators are not allowed in an arbitral tribunal. So you can go for 1, 3, 5, 7, but not 2, 4, 6, 8. All right. Also, the parties are free to decide the procedure for the purposes of appointment of the arbitrator. The parties are free to decide that what qualification an arbitrator is supposed to have. If they want a person who is well qualified in commercial matters, then they can appoint a person who is an expert as an arbitrator. If they want someone who is an expert in, um, you know, construction disputes, then the qualification is completely up to the parties. They can decide the qualification, and according to the qualification, they can appoint the arbitrator. Now, as I said, the qualifications are completely left to the parties. However, what is required is that the person who is being appointed as an arbitrator should be able to act in a fair and independent manner. So the arbitrator should be neutral. And in order to ensure that the arbitrator is neutral, we have to ensure that the arbitrator does not have any kind of direct or indirect relationship with any of the parties to the dispute, and also does not have any kind of interest in the subject matter of the dispute. All right. So, according to the Arbitration and Conciliation Act, any person who has been approached to be appointed as an arbitrator has to make a disclosure that that he does not have any kind of relationship, or he does not have any kind of interest in the subject matter of the dispute. If he has any interest or any kind of relationship, then he is supposed to disclose it to the parties. Then the parties can take a call whether to appoint such a person as an arbitrator or not. But it is the duty of the arbitrator to ensure that he makes an honest disclosure before his appointment is finalized by the parties. However, his appointment can be challenged if at a later stage it is found that he was not being honest about his disclosure, and he has some kind of relationship with one of the parties, or has some interest in the subject matter of the dispute, either directly or indirectly, or the person does not possess the qualifications that was decided by the parties. All right. So even once a person has been appointed as an arbitrator, his appointment still can be challenged by the parties. But that challenge has to happen before the arbitral tribunal itself. All right. So the arbitral tribunal will get to decide that whether the appointment of the tribunal is valid or not. So this is known as the principle of competence, which is that the tribunal gets to decide on the question of its own competency. That is, the tribunal gets to decide on the question of its own jurisdiction. Okay. Now, as far as the conduct of arbitral proceedings is concerned, as I've said, the entire CPC is not applicable to an arbitration. Indian Evidence Act is not applicable to an arbitration. So it is completely up to the parties to decide that what procedure they want to follow, what rules of evidence they want to follow. If they're not able to decide it, then the arbitrator, with the consent of the parties, can decide the procedure that is supposed to be followed for arbitration and the rules of evidence that are supposed to be followed. The parties can also decide that the place where the arbitration is supposed to be conducted. They can also decide what will be the language of the arbitration, and then consequently at that particular place, the parties and the arbitral tribunal can actually conduct the arbitration proceedings. Now, the arbitration proceedings, because it involves adjudication, so it will involve submission of arguments, it will involve submission of evidence, including evidence given by witnesses. It might also involve opinions given by experts. Okay, so there's a possibility that the arbitral tribunal may call for the expert opinion on a particular subject matter of the dispute. So after going through all the evidences, after going through the expert opinion, and also the written as well as the oral submission of the parties, the arbitrator comes to a decision. And this decision of the arbitrator, as I told you, is known as an award, is known as an arbitral award. Now, an arbitral award is final and binding on the parties, which means that they can't deviate from the decision that has been given by the tribunal. They can't say that I'm not going to follow this decision. They are bound by their decision. Okay, which also means that no appeal lies against an arbitral award. However, an arbitral award is supposed to be in writing. Oral awards are not recognized in India. It is supposed to be in writing. It is supposed to be signed by all the members or all the arbitrators of the arbitral tribunal. It is supposed to mention the date and place where the award has been passed, and it is also a copy of it is supposed to be signed, and then it is supposed to be sent to each of the parties to the dispute. All right, then only the award becomes enforceable. However, no appeal lies against such an award. However, even if no appeal lies, we can challenge the award. All right. And where do we challenge it? We challenge it in a court of law. Now, the difference between an appeal and a challenge is that in case of an appeal, an appellate court has a lot of powers. An appellate court has the power to modify the decision, has the power to turn down the decision. However, in case of a challenge, a court has very restrictive powers. It can't modify the award. It can only set aside the award. It can only nullify the award. However, it does not have the power to modify the award. And also the grounds on which the award can be set aside are very restricted. If there is any ground which goes beyond what is mentioned under Section 34 of the Arbitration and Conciliation Act, then that ground cannot be accepted. The court does not have discretionary power in that circumstance. All right. So we can't appeal against the award, but we can challenge the award, and therefore the court has the power to set aside the award. Once the award has been set aside, the parties, they come back to scratch. They come back to ground zero. Now, again, they have to look for some way to resolve their dispute, because even though they went through arbitration, even though they got an award, but now that award has been set aside. So it is as if they never underwent arbitration. They did not have any award in the first place. So now they're back to square one. So now again, they have to look for other ways to resolve their dispute. So now they can go for probably litigation for the purposes of resolution of the dispute, or they can go for other ADR mechanisms as well. All right. Now, so this is the entire arbitration process that I have discussed today in brief, in short, and I hope that all of you have understood this entire procedure. And thank you so much for giving me the time to uh, understand the basics of the Arbitration and Conciliation Act 1996. And if there are any questions, I'm open to them.
Thank you so much, Navita ma'am, for your kind or I can say valuable session. Now we open the floor for questions. In case,
Hello.
yeah, in case anyone have any question, please
Yes,
raise your
I
hand.
have a question. I have three questions, in fact. Please,
Yes.
So
listen
once,
to the questions because I may not get a second chance of speaking.
yeah, please, I request participant, please raise your hand, because everybody
There
will
is
start talking.
this thing here, hand being shown on the screen as usually it is.
Okay, please, no
So-
problem. Please carry on. Over to you.
Yeah. So the first question is, you specifically said that in ad hoc arbitration, decisions of the parties are supported by the Arbitration and Conciliation Act. So my question is, what about decisions of the parties in case of institutional arbitration? Are they not supported?
In case of institutional arbitration, every institute has its own rules. So if you, for instance, SEAC has its own rules on arbitration. Uh, IAMC has its own rules on arbitration. MCIA, they have their own rules on arbitration. So there, the decision making is supported by the rules of the institution and not particularly the arbitration law.
The second question is, thanks for this, the arbitral tribunal will decide about its own competency, you said.
Yes.
Okay, and I found it against the principle of one cannot be judged in one's own
Yes.
matter. So what do you
Yes.
have to say about it?
So basically, this provision has actually been criticized a lot on being against the principle of natural justice, which is one cannot be a judge in their own cause. But that is what is happening in arbitration. That if we are saying that the arbitrator is biased, then we are making this contention before the same arbitrator. So yes, you are correct. This provision has been criticized on this point, but we have not seen any amendment as far as this provision is concerned.
The third question is, if arbitral award is set aside, can parties not go through the arbitral process again by appointing another arbitral
They can
tribunal?
go for another arbitration.
Okay, thank you. Lecture was very nice. Thank you very much. Very clear.
Thank you so much.
Question, participant, you can raise your hand. There's a question, a difference between seat and venue with an example.
Okay. So as far as Indian jurisprudence is concerned, we are still very confused about the difference between seat and venue. But to give you a very basic idea about it, the significance of seat is twofold. If we choose a place as the seat of arbitration, then we submit ourselves to the arbitration law of that particular place. And secondly, we submit ourselves to the jurisdiction of the courts of that particular place. So, for instance, if two parties choose India as the seat of arbitration, then the Indian Arbitration Conciliation Act 1996 would be applicable to that arbitration. And secondly, the courts in India will have jurisdiction, supervisory jurisdiction over that arbitration. Venue is basically if, because for the purposes of convenience, or for some reason the parties are not able to conduct the arbitration at the place of seat, then they can conduct it at any other place. However, if for instance the seat is India and the arbitrator is from Germany, so for some reason the arbitrator is not able to fly to India, so the parties, they go to Germany and they conduct some part of their arbitration proceedings in Germany till the time the arbitrator is able to fly to India. So in this case, the parties have not submitted themselves to the arbitration law of Germany, or they have not submitted themselves to the jurisdiction of German courts. Only for matter of convenience, they are conducting some part of their arbitration proceedings in Germany. That makes Germany the venue, but India continues to be the seat of arbitration.
Next, Srinivas MP.
Good evening, sir. Good evening,
Yeah.
madam.
Good evening, sir.
Madam, who will enforce the arbitral awards, madam? Is there
Courts.
any mechanism
Courts
to
will
enforce the arbitral awards?
Yes, sir. So it is given under Section 36 of the Arbitration and Conciliation Act that it is the courts which will enforce the arbitral award as if it is a decree passed by a civil.
Madam,
So
even
yes,
court orders are taking long time to enforce them. Execution petition and all, it is
Yes.
taking another 5 or 6 years.
Yes.
Then arbitral awards also take same time.
Yes.
Then what is the use of arbitration? I am unable to understand, madam.
So that is the problem that we are facing, that ultimately we wanted that entire arbitration should happen without courts being involved, but we have not been able to achieve that. So at some point or the other, whenever the courts get involved, the delays, they happen in case of arbitration, and that is why we are not able to make our India as a arbitration hub.
Then the object of the law itself is defeated, no, madam?
I understand that. So basically, now if you read the Arbitration and Conciliation Act after 2019 and 2021 amendment, they have put certain timelines for the courts as well. That you are
Yes,
supposed
madam.
to
For
dispose of the
everything, there have to
application
be.
within this particular timeline. But again, they are not, they're not bound by those timelines. The courts, they're not bound by those timelines. So the legislature is making the efforts of making arbitration much more speedier in India, but we have not been able to achieve that as of now.
Thank you, madam. Thank you.
Okay, participant, I think some answer you will get in next session. So I request you, right? We won't be able to take more questions because we have another session lined up, arbitration procedure. So I can see more questions will be covered in next session. So please hold your questions. So over to you, Hiranshi.
Yeah, thank you so much, Nuvita ma'am, for this wonderful session. It's our pleasure to host you not only just as keynote speaker, but also as a professional board of Sambhav initiative. Thank you so much, ma'am, and thank you all participants for eagerly join this session and ask your queries. We'll take your some queries in another next session. Thank you so much,
Thank you
ma'am.
so much.
Thank you.
Thank you so much for the
Thank you.
invitation. Thank you.
Thank you,
Thank you.
ma'am.